the last couple of years, there's been a lot of legislation that's been proposed about the Access to Public Records Act and the Open Meetings Act. And through our office, we've had the opportunity to work with members of the press and to talk about these issues. And we're certainly not going to agree on every single issue, but we certainly, I think, had a very good discussion and a very honest discussion about what the law is and what the law should be. And there are things that we all agree on, and there are things that we don't agree on. But through that discussion, we found that I think talking to some members of the media and through myself, that having that discussion was very helpful, and that's one of the things that we're hoping to achieve through this panel discussion. Starting all the way on the left is Tony DeSisto. He's the solicitor for Warren and Lincoln. And to Tony's left is Sheila Maloney. She's the executive editor of the Newport Daily News. Sheila is actually the veteran of the panel discussion. She had been on one of the prior discussions that we had, that I just alluded to. And to Sheila's left is Tim White from WPRI, Channel 12. He's the investigative reporter. I kind of feel like I'm in Tim's role right now. So, one of the things that we're going to start with, and we highlighted some of the cases that we've had in the last year, but one of the cases I didn't talk about was a case by one of Sheila and Tim's colleagues, Jim Hummel. And I want to start with that case, and we purposely saved it for this part of the discussion because I think it's an important case. It's a very important case, actually, and we wanted to highlight it. It's in the summaries of our book. It's Jim Hummel versus the City of Central Falls. And just to explain what that case was, Mr. Hummel requested in February of 2010, he made a request to the City of Central Falls for the open session minutes to one meeting, a meeting that happened in December 2009, so a meeting that happened about 2 months earlier. He was told that he had to wait 10 business days under the Access to Public Records Act, where the city had 10 business days to respond, and that they had forwarded his request for the open session minutes to the town solicitor to make a determination whether or not those records were public or not. Just for a show of hands in the main room, the question really became, did the City of Central Falls, we obviously talked about 10 business days to respond. By a show of hands, how many people in the main room here feel that the City of Central Falls violated the Open Meeting Act by not responding to his request within 10 business days? But they actually give you the other fact, the important fact. The city responded to his request within 6 days. So they responded to Jim Hummel's request 6 days after he made it, or 6 business days. Did they violate the Access to Public Records Act by providing access after that 6-day period, or within that 6-day period? How many people think that they did violate the Act by providing access within 6 days? Nobody in the main room, or nobody just raising their hands?
I'm not sure I understand.
They provided access to the open session within 6 days or 6 business days after the request. Did they have to provide access within, earlier than the 6-day period, or did they have the 10 business days to respond, as we talked about earlier, for the open session minutes? That's really the question. So, how many people here, let me phrase it differently, how many people in the main room think that the City of Central Falls had 10 business days to respond to his request for the open session minutes? Probably at least half the people in the room. We found that the City of Central Falls violated the Access to Public Records Act. More specifically, they violated the Open Meetings Act because they failed to respond to the request for the open session minutes within a quote-unquote reasonable time. And let me start with Tony on the panel. Why did we arrive at that decision? Why did the City of Central Falls not have 10 business days to respond? And why did we find that there was a violation in that situation?
The term that comes to mind first is jackboots. Just kidding around, I think the decision came under the Open Meetings Act because you were dealing with minutes from an open meeting. Those to be made available within 35 days. And because it was a routine record, it should have been something that the requester could have gotten by going to the clerk's office without having to rely upon an opinion from the town or city solicitor in this case. The only reason I make the first comment is that the one thing that I see from reading the decision is that there was no allegation that there was some harm to the requester and delay from the time asked to the 6 days going forward. The only reason I say that is because you have that 10-day time limit under the Access to Public Records Act. I understand the decision and I don't disagree with it. The only thing that concerns me is the determination was 6 days was too late. The question then becomes, is there some other time limit? If it's not produced immediately, for whatever reason, it may be a legitimate reason, if it's not produced immediately upon request, is that also a violation of the Open Meetings Act or perhaps the Access to Public Records Act? I only say that because we're in a cycle now where municipal budgets are being reduced, and very many towns and city halls are seeing a reduction of personnel in clerk's offices. And it may be difficult at that time if something else is going on, elections have to be certified or signatures, whatever. It could be difficult to respond immediately to those types of requests. That's the concern I have under the case, but I think the rationale is correct under the Open Meetings Act. You have essentially two categories, and this was a routine request that was produced fairly quickly.
Tim, you wanted to respond, but let me just, because there's a practical aspect that everybody here is going to have to comply with these laws, let me just make it clear what Tony had just raised. In that case, we said that 6 business days, responding within 6 business days violated the Act because the city hadn't provided us any evidence that they couldn't have responded earlier. In other words, if there had been some evidence that town personnel were doing other responsibilities, or the records were in storage, or something to that effect, that would have altered the decision on a case-by-case basis.
Yeah, I have a non-legal perspective, obviously, of the assessment on this one, and to the degree that, sure, they complied within 10 days, they got it on the 6th day. I obviously agree with the Attorney General's office finding, but the non-legal view I have it is they were clearly busting chops on this one, which happens quite a bit, and the open minutes from an open meeting, I mean, talk about as fundamental of a public record as you can get. And it's not like Jim was asking for, you know, the entire pension roll of the municipality, which would take a lot of time to compile or something like that. This was something that really reeks of a delay tactic, when clearly something is, there's no question about whether or not it's an open record. So to me, again, a non-legal perspective, that's what it was. It was busting chops.
I want to go to Sheila in a second, but just to pick up on Tim's point about obviously this was a public record, and Tim and I had talked earlier about this really being probably the quintessential public record. Referencing again the public book, the bound book that we have, 42-467B, on page 28, it says that unofficial minutes have to be made available to the public within 35 days of the meeting or the next regularly scheduled meeting. And that was really part of the analysis that Tony was referring to earlier. These records have to be made available. Now, as we talked about earlier, and as Tony had just mentioned, if there were certain facts that came up that, you know, town personnel were doing something at that point, that might affect when the reasonable time frame was. But short of that, you know, these are public records. They have to be made available, and they have to be made available, you know, within that reasonable time frame.
Can I ask a question? A follow-up question to that is just for future reference. Is that a request that should have been made under the Open Meetings Act then, instead of the Access to Public Records Act? Because I certainly agree with Tim that we've seen in just asking for routine documents from public agencies that they will take up to the 10 days that they have to respond, even if it's not something that is a voluminous request, which a lot of times when we make requests like that, if it's municipal salaries, payroll records, we work with the municipalities, we know that it's a time-consuming process, and we ask for them well in advance and, you know, work with them as much as possible. So is that something, if you're looking for minutes, is that a request that should be made through the Open Meetings Act rather than the Public Records Act?
I think that was
what
what
helped.
I think that's what. I think the fact that the request was made under the Public Records Act confused the situation a little bit. And in fact, when we sent out the letters initiating our investigation, our review, we asked the town to respond to the open meeting aspect. We specifically quoted in our letter, you know, does the 10 days apply under the Public Records Act, or does the Open Meeting Act apply where the records have to be made available within 35 days of a meeting? You know,